My lord,
What is this matter is there?
my lord,
What challenge this is against what?
against the order rejecting the discharge petition, your lordships. My lord, current status of the trial is that charges are being framed. So, my lord, this matter stands infructuous. So, all I pray is liberty to withdraw to file a better
And
application.
with the liberty to raise all the points before the court.
In any appropriate stage, my lords.
Yes, right. This is a petition whereby the petitioner has challenged the order dated 16/10/2023 passed by Lieutenant Civil, what is? Vigilance Court.
Special Judge Vigilance, Dhenkanad.
Annex 1, no?
Yes.
Passed by the Special Judge Vigilance, Dhenkanad in TR case number 8 of 2023, whereby the application of the petitioner under section 239 CRPC seeking discharge has been rejected. Counsel Mr. Das and counsel for the petitioner submits that meanwhile charges have already been framed. Therefore, he seeks to withdraw this petition to raise all his points before the court below at the appropriate stage. With this liberty, the petition is disposed of. Yes.
Item 2. Item 2 is requesting for passover.
Passover?
Passover, yes, ma'am.
Yes.
After lunch, this item may kindly taken out.
Passover after lunch only. Yes.
Item 3.
Yes.
Today I have filed Bhoklatnama for OP number 2, my lord.
Cancellation.
Cancellation of bail.
What are the grounds?
Can she, my lord, Joseph has passed an order, my lord, directing the accused to deposit, my lord, the amount. Can count to page 13. The
Yes.
order, page 13, my lord.
1-3. 1-3? Okay.
Yes, one second.
Yes.
The petitioner shall comply the undertaking by making payments. Payments is, my lord, that is at page 12, paragraph 4.
Yes.
And counsel for the petitioner on instruction submit that the petitioner is ready and willing to pay total amount taken by him in the lieu of the selling of piece of land. Without giving the money, my lord, you are released on bail. In our trial court, one can see the order from trial court is passed, my lord. That is at page, my lord. The at page, no, that is at page, my lord, page 33, my lord.
33.
33, my lord.
Yes.
On trial court, my lord, only has given the, my lord, the direction to punish the my lord, the bail bond, and no cash was, my lord, imposed upon the accused to deposit, my lord. Straight away, you are released on bail, my lord.
You have undertaken to this court that you on instruction you said that I'll pay. After bail you won't pay. What is this?
Sorry, passover, my lord, senior Nahanti Koribari.
I'll recall the order then.
Yes.
If you don't pay, or otherwise I can give you time. If you have any problem, I can give you time. That doesn't mean that you will not pay because you have
One time.
this is playing game with the court.
Exactly.
Exactly. This should not
To
be.
take
On good faith, you will also pass the order.
an order, you
Yes, sir.
concede something.
On their submission, man.
And
Yes.
you are
That's
submission.
On his
I can't
submission.
help it. If the court would have said, one can understand. But you yourself have said only to take the benefit of the order. Now, I am passing it over. Otherwise, I'll recall.
One time.
And tell your senior that I can accommodate to the extent that you need some time. I'll give you the time. You may have financial difficulty, no problem. But I can give you time. I can give you time.
Yes, sir.
But you have to comply the High Court order. Okay. Pass over. Huh?
Pass over.
Let him get instruction.
ठीक है
Senior not.
Friday रखो ना Friday रखो कल ही रखो तू
next week.
Then okay, no, not next week. These kind of matters are unnecessary. Friday. Huh?
Friday, yes, ma'am. Friday.
Day of, and tell your senior
Yes, madam.
that the court says that if you want time, he gave. Otherwise, he'll recall the order.
Recall, yes.
Obligation. Get ready. What is the amount, by the way?
5 lakhs, madam.
$5. Whatever.
Exactly, he has undertaken to give the amount, madam.
But once the payment is made, the case should be closed.
That.
Why unnecessary? You will prosecute.
Yes, madam. Definitely, madam.
You pay the money and finish it up.
Yes, madam. No.
I'll record that also.
Yes, also.
Once
Yes,
payment is made,
madam.
parties have agreed to move appropriate petition
Absolutely,
under
yes. There's
482
no-
for Kwachi.
there's no
That
bar.
is also recorded.
Yes,
Not that you take the money and
No
prosecute.
problem, madam. No problem.
ठीक.
On Friday. Hon'Ble.
Item 4.
Data record code in this.
He has filed Vokalatnama, he taken on record, please come.
May I please? The present application is regarding the modification of order dated 6/3/24 passed by the Honorable ADJ Bhubaneswar. Cash surety, Your Lordship, rupees 2 lakhs. Cash surety is rupees 2 lakhs, which is the petitioner is unable to pay, Your Lordship. Kindly modify into any other condition.
You see whether you have, from your side you have said that the court said.
No, Bhubaneswar, ADJ Bhubaneswar put condition of cash surety of rupees 2 lakhs.
That is not correct. But they have highly anticipated here, madam.
Your Lordship.
In the while December court disposing the anticipated well, directly they on their submission, madam, one condition imposed subject to payment of depositable bill.
Where is that? Where is that?
Page 17.
Page 17.
70.
Page
Your
16.
Lordship, in between, I was arrested, Your Lordship.
1 minute. Okay. You have said that. In such event, we shall be released on bail and such terms and conditions we do petition proper.
Subject depositable 2 lakhs towards cash ability. Such the court, madam. Here, madam, they. This petition, madam, they issued check and in cash. Thereafter, madam, they did not deliver the vehicle for that reason. And they have come here for anticipated well.
Your
For that,
Lordship.
You get the money?
Your Lordship.
You don't give the car also? You don't want to pay the money?
Your Lordship, I and my husband both are behind the custody, Your Lordship.
Preventive custody.
No, in judicial custody, Your Lordship.
Why?
From
They have not complied, madam.
not complained.
Not deposited, madam. For that reason.
This is regular bail.
Yes, Your Lordship.
After, madam, obtaining order from this court, madam, and
No, this is anticipatory bail.
anticipated. Thereafter, here, their submission, they have.
They could not arrange the money. So,
Arrangement, and he has been arrested.
And arrested, Your Lordship.
But that is not the manner, the question manner. Even the manner brought before, arrested or produced before the court manner. Same meaning manner.
that's right. But the problem is,
Already, he has manner the file modification in the able appeal. In portion
No.
of this order, this the lower court manner impose the condition of 2 lakhs manner.
Your Lordship.
And
Your
that
Lordship,
that
you are
order
in
passed by-
custody. You are in custody since
21st December 2023, Your Lordship.
that order-
21st December 2023.
23.
23. 21st
that
December.
order passed by the coordinate bench manner. They were a proper manner, they have to move the appeals there for modification manner.
No, my lord.
And that able appeal.
Your
So that
Lordship.
the court below manner, and see, court below manner, the impose the condition manner.
Anticipatory bail order cannot be furnished, Your Lordship.
No, while dealing with the matter, the page 10 matter. Perusal, the order dated at 15/11/2000 passed by the ABL of such and such. Honorable High Court of Orissa, wherein the Honorable High Court directed to release the petition on bail on certain terms and conditions subject to depositable 2 lakhs towards cash.
Your Lordship, this is the application after arrest.
Consider this file of the.
Your Lordship, after arrest, this is filed before the learned lawyer court, learned ADJ Bhubaneswar, Your Lordship. After arrest, Your
I
Lordship.
know
Meaning is same matter.
you did not pay the money as per the anticipatory bail. Therefore, you are taken into custody. Thereafter, you are now granted bail, and 2 lakh rupees is imposed. When was the bail granted to you?
6/3/24, 6 March 2024.
We are in July. See, the problem, Mr. Raghuda, is
Matter. If
the fact remains that he doesn't have the money.
Yeah.
Otherwise, you would have come out.
But the court will have not committed any wrong matter.
No, that's right. I'm not on that. I'm not on that. But the fact remains
Yeah.
somebody's liberty, and you can't curtail because of
This is the situation, madam.
this is not the law, in fact.
For that reason, matter, the non-court below matter impose the.
And she
That
is
is
a
a-
women.
Your Lordship. I have a minor daughter, Your Lordship.
Manner, whenever manner this court matter, pass order matter, assess order matter, taking to the submission of the.
That's right. But
After
she is
you-
a woman having a child to March. The order was passed. If you would have that kind of money, you would have paid by now. You would have come out.
You know,
We are in July.
but the judicial and their manner, they anticipate well for that matter. But after, why I have to say something so my lord, one case my lord, I was the counsel my lord. This one court my lord in the 2007 paragraph, my lord. This one granted bail to the accused person if the petitioner surrender before the court will they shall be released on bail. That is the condition. On the way, while they are going to surrender before the court, on the way police arrested them. Not at court below, remanded them, saying that Honorable High Court said if the petition
Shall I list it before Justice
It will
Sankar
better.
Mishra tomorrow?
No, your lordship. Kindly pass any
You will
approval.
get the same order, don't worry. Because ideally what he says is the condition was in fact imposed by that court. Ideally it should go to that court. That's what he says. Nothing else. He is not opposing.
Nah.
But he is only saying that it should go to that court. I'll put it tomorrow.
Your lordship, that case different, your lordship. Anticipatory bail already disposed of.
That's right, you are right. But the condition flows from that judge, that order only.
Your lordship.
The condition imposed by the trial court is flowing from that order.
Exactly.
So therefore, what he says is he is not opposing your waiving condition. He says that the propriety is it should go to that court. That's what he says. I'll
Otherwise,
list it
my lord,
tomorrow.
if they move on IA, my lord, stating that the person already arrested in the birds.
I will direct to list this matter before Justice Sankar Mishra tomorrow. That's the best way. Why to already he is still suffering. Right?
After arrested, this was.
That's right. Okay. Let us see. It will happen tomorrow. Don't worry.
Sincerely, I'm not assent to that. Your lordship.
Huh?
Sincerely, I'm not assent to that.
No, I'll write that
Madam.
since it is flowing, so therefore it should
Madam.
go to it. Right down. In the present petition, petitioner is seeking variation of the bail condition. Bail condition imposed by the third additional sessions Judge Bhubaneswar in BA number 370 of 2024. 2024, whereby while admitting the petitioner on bail, she was directed to deposit 2 lakh rupees as a cash security, cash security. Land Counsel for the petitioner submits that although the bail order has been made on 6/3/2024, because she could not arrange the cash security, as a result of which she is still continuing in the custody. The petitioner has a minor daughter. Minor daughter. I perused the record and found that the condition said condition has been imposed by the trial court on the basis of the direction. On the basis of the order dated 15/11/2023 passed by the coordination of this court while disposing of AVPL number 13120 of 2023 moved by the petitioner herself. Since the condition is the condition so imposed by the trial court is flowing from the order of the coordinate bench, I feel it appropriate to feel it appropriate I feel it appropriate that the said petition should also be listed before the same bench, subject to the approval of the Chief Justice. Leave the matter before Justice Sankar Mishra tomorrow.
He wants approval of the Honorable Chief Justice.
Subject to approval. You will no, sir, immediately.
Tomorrow.
Immediately.
But it will take time for approval of.
Immediately, at 12 o'clock, get it signed from me and send it. It will be issued tomorrow.
Item 5.
Yes. What is this matter? To cause
5.
NBW.
Extension of. Copy not served, extension of time.
Extension of time.
Dispose of case.
For the reasons stated in the application, the prayer for extension time cup. I had given time till.
They have not given.
What's on? For the reasons stated in the application, the extension of time for surrendering appearing before the court below is allowed, and the petitioner is directed to appear before the court below on or before 20th of August. March I had given. 7th March 2024, you were supposed to appear, just a month. 20th of August, subject to petitioner paying a cost of rupees. Labor तो नहीं है. Subject to the petitioner paying a cost of rupees 1,000 to the Orissa High Court advocates welfare efforts. 1,000 rupees I have imposed. Because see, 7th March I had given. Now he is moving application. Yes. And secret, yeah. Appeal before secret, yes.
Item 6.
Lordship, I am for the petitioner.
Yes.
Lordship, may have a glance of the order 6 May 2024, para 3.
Para 3.
Lordship,
Subject to the petitioner appearing before the court below on for the. What do you want?
Lordship, extension of time of 6 weeks. Lordship, he having a genuine problem. His father is suffering from cardiac.
All right. For the reasons stated in the application, the petitioner is seeking extension of time to surrender appear before the court below in pursuance to the direction dated 6/5/2024 passed by this court. For the reasons stated in the application is allowed. Petitioner is directed to appear before the court below on or before 20th of August.
Lordship.
20th of August 2024 and avail remedy under law. With this condition, with this observation, the application is allowed.
Obliged.
And it's made clear in both the applications. Made clear that no further extensions are being. Otherwise, again you will come move up.
Item 7.
Extension of time.
Time to surrender.
Time to surrender.
You are given time till
2 weeks. Till 30 June.
30th June.
June.
Right on. Petitioner is seeking extension of time to surrender appear before the court below pursuant to the direction of this court dated 15/5. What was the order?
My lord, order passed for to surrender the
15/5/2000 pursuant to the order dated 15/5/2024 passed by this court. For the reasons stated in the application, the extension of time is allowed. The petitioner is directed to appear or surrender before the court below on or before 20th of August 2024 and seek remedy available to him under law. And it is made clear that no further extensions are given. Yes.
obliged.
Item 8.
It's item 8 on behalf of Mr. Srimanta Das. He met with an accident. Lordship knows. He taken a 1
Lords,
week.
I also require some time to file the objection, reply to the objection.
Okay. Next.
Can it come after 3 weeks?
3 weeks.
Yes.
4 weeks process.
These matters are pending since 2015. Why 3 weeks, sir?
1 week.
2 weeks.
Next.
Lordship, may accommodate 4 weeks, Lordship.
When Mrs.
1 week after marriage.
He says 1 week. 1 week.
All right,
after,
my lord, let it come.
after 1 week.
Yes.
Yeah.
Your Lordship, the
Get
name
ready.
of,
We will finish up these matters. Unnecessary pending.
My lords,
Yes.
Your Lordship, in item 8, Your Lordship, the name of Mr. Dhanidhan Naik and associates may be deleted, Your Lordship.
Acha. Name of Mr. So delete. 1 week after. 1 week after. Yes. 1 week after.
Yes, ma'am.
He will be all right.
Hopefully, ma'am.
6th. Yes.
Great one.
2 weeks.
Item 9.
Item 9, my lord, it is it is ready for hearing. It may be taken to the hearing list,
Yes.
weekly list here.
Therefore, okay, yes. Yes.
Item 9. Item 10.
Item 10 is a 2023 appeal. Maybe tagged up in the weekly minutes.
That's inadvertently somehow it has come in for orders, my lords. It's a hearing matter.
Then let it come in the
Weekly minutes.
Yes, ma'am.
Week. Yes.
Item 11.
Deeply.
Under section 498/3480. Well, at the present petitioner.
Well, I may be pardon, item 10
Yes, sir.
Actually, my lords, I'm sorry, this network problem was there. Item 10, I'm appearing in the matter. Your lordships is proposing to keep it on the weekly list.
Yes, if you are ready, we can take up anytime.
No, my lords, I will be filing an application under section 391 CRPC for additional evidence, because what has happened in this,
If you move such application, that will come
yes,
in the supplementary list.
my lords,
Please.
I'll move it and I'll mention it before your lordships.
Yes,
An
yes, please.
application under 391 for additional evidence. Obliged. Obliged.
Welcome.
My lord, the petition faced the trial 306 along with 498 34 IPC. My lord, he acquitted. My lord, the abatement of suicide he acquitted and convicted under section 498 and 34 IPC. And near about, my lord, 3 months inside the custody. Inside the custody. And
to actual the charge frame order 498 306 34 IPC madam. They have acquitted 2 persons convicted 498 34 IPC my lord. And the co-accused my lord, though he has been not acquitted my lord, the court stated that till rising of the court of punishment given my lord. So for this petition is 3 months.
3 months undergone.
3 months.
3
And
months
your lordship last
3
occasion.
months undergone already undergone.
No, तारा दीटा पिला. तार पचार चले.
Okay, already undergone. Why? What was the sentence otherwise for you?
2 years.
2 years.
And the other accused is convicted?
That is the mother-in-law.
Mother-in-law, 80 years old.
Till rising of the court.
Till rising of the court.
Already undergone, but fine?
Fine, my lord, 2,000.
I'll increase the fine.
Increase fine, that will
Increase, fine increase, fine increase.
If realize that has to given to this
357. 350.
2,000, my lord, 2,000 to 5 inch.
How the chatter soon pocket fine increase, period already. Maybe they do. Okay. This matter was pending since 2014. Incident of
2009.
one thing, my lord. This is another case. This is expired, my lord. If the fine amount to realize, my lord, that will be deposited in the name of a
children.
Right down. 357, the 357. Thank you. The fine amount to be deposited. Fine amount to be deposited shall be disbursed to the minor children.
Major region, 6 years and 10 years at the time of my lord incident.
To the children for the deceased wife and the children are to the children. Son and daughter.
Son and daughter.
Son and daughter of the petitioner. Only daughter. To the daughter. To the daughter. In the name of daughter. On the name of daughter. That should be some console. Some console, nothing else. Yes.
Item 12.
This is a case of.
What are you doing, by the way? Let us understand. Huh?
From the evidence from the statement of the daughter of the deceased, my lord, the husband of the deceased working as a driver.
Private.
Yes.
Item 12.
May I please, your lordship? This is a case of 2003. At the relevant time, the petitioner number 2 has 55 years old. Whether he is alive or dead.
57 years at the time of judgment.
2014. 57, 67.
No, my lord.
2004, my lord. City case on 13 2004, my lord. Page 6. About the cost title, my lord. Pushkar Naik, about 57 years.
Yeah, but here, who is here? Kulamani Naik and Pushkar.
2004, my lord, 57 years. Mentioned 2004, 57 judgment, my lord. Answer 1, page 6.
Yes.
57.
Kulamani Naik was 23 years.
My lord.
And Pushkar was 57. Pushkar must be now very old.
77.
17.
Pushkar.
But in Kulamani Naik, is 20.
Kulamani
That
28
time he
years,
was 20.
28 years ಆಯ್ತು.
Huh?
20 ವರ್ಷ past ಆಯ್ತು.
He was 23 that time.
But page 1,
28 means 48.
trial court, 2004.
Yes, he was 23. Kulamani was 23 in the year 2004.
33 or 40?
Wait, 1 minute, for my LCR will see.
That's
Charge sheet.
Charge sheet Pushkar thila 55, Kulamani thila 27.
27.
Mala.
That is the.
this number, I will place you.
Kulamani was 27
Mala.
at the time of filing the charge sheet. Charge sheet was filed in the year 2003.
See,
What is the age now? 27
plus 20,
Huh?
21, 50, 48. Now he is 48.
48. Yes, tell me.
The
Offense is under?
307 faced the trial, convicted
Yes.
for a period of 3 years and subsequently challenging the appeal. That was modified, RI for 1 year for offense 324.
Both of you.
Both
Yes.
the appellants.
You have a case for acquittal.
No. Eyewitness, doctor's evidence, eyewitness are injured. Three statements are there.
What are that case?
Injured statement, eyewitness statement and doctor. Actually, my lord,
Undergone? Undergone?
Undergone custody. He was in custody for few days. There was
Tell
a
me.
forwarding report, but
Tell me how much.
high 16/5/2003 ରେ ଯାଇଥିଲେ custody ଆଉ ତାପରେ release date
Undergone is also not there.
LCR is there, my lord.
Just check it up. You will check it up and tell me period already undergone. And what was the sentence? 3 years.
1 year.
1
year.
It was
By appellate court, 1 year.
by
1 year.
Just see if you have undergone little substantive period, then we'll see. Or I'll reduce it to 6 months.
But for a small,
Actually, my lord, the appellate court has only considered that the nature of injury. He has not considered what is the intention. Because they have asserted by means of Tangia and
And yeah, where? Which part?
to the head man.
Head.
But he has only, appellate court only considered that though injuries are simple in nature, so there is no intention to. That was the para 9 my lord clarified appellate court. Para 9 of the judgment my lord clarified.
Para 9.
Para 9 of the appellate court.
And converted to 323.
It was 324.
3. It's all right, but we increase the fine
Only
and
that,
period under
only that person appellate court has taken into consideration.
because there are two injured.
Two injured.
Two injured. Both of them have deposed.
But
So what we'll do is we'll increase substantially the fine and the period already undergone. You find out
my lord.
how much you have already. Find out and tell me.
I will.
Huh? In so far sentence is concerned, what we'll do is PO already if substantially if you are undergone and the fine will increase substantially.
There is no fine by the.
No question of acquittal.
and my lord, specific
Find out and tell me.
specific allegation is against the petition
It's
number
all right. I'm not
Petition
executing.
number 2. At that time he was 65. My assumption is that in the 2014 he was 65.
That's right. One of them. The other Kulamani is
Kulamani is 36.
he was 36. 30. So therefore, it's better that yes, judgment is and you tell me undergo and give the file to me. Yes. Next. Yes.
13 lots, I pray lots, I have to discuss with my learned counsel lots. This is a matter, Lord, takes some time, Lord. My learned sister has got time tomorrow, she is free and on Tuesday, my lords. Tomorrow that MJQ matter is coming up. That's a my lords, I suggest, my lords.
It is against discharge.
But it's a lengthy matter. My learned friend,
My lord, the case was heard by Honorable Justice S.K. Sahu, and it was almost on the verge of writing the judgment.
No, in fact, it's
That is a long story now.
My lord,
That has become history.
my lord.
Now I need to hear it because I
very
think
question, at least 3-4 days, my lords. I argued. In fact, my learned
no, was
sister
there any stay operating?
is entry model is there.
No, my lord, interim order is not there, and
Then the
29.
charge might have been framed by now.
No. The entry model is a prayer for adjournment was there.
29th रे अच्छी lower court रे मतलब
I'll vacate the stay.
stay नहीं my lord.
Don't ask for adjournment. Let the trial court examine and see. Why are you asking time? 2015 matter.
Let's
We can finish it up.
let's let it come then tomorrow or Tuesday, my lords.
Tomorrow, Tuesday. Keep it in Tuesday. Yes.
My lord, please ask for the lower court may be told to give a time direction to for a
No,
time
I
on
will not say
29th.
anything. Simply you are asking for time, I will not say. I am not in favor of this kind of interim orders, and either argue the matter and finish it up and
My lord, I'm ready to argue, my lord, completely.
argue your part. I'll hear him on Tuesday. Argue your part. Will you argue now?
I will argue, my lord.
Pass it over. Let her argue. Yes.
Item 14.
Yes.
This application is against the order of framing of the charge, Lordship, for the alleged offences under section 13(1) CD punishable under.
This will take little time. I'll just run through the supplementary. You be here. I'll take it up.
Then.
So that will continue.
But in this case, I am
For the other-
appearing. I am appealing for the state vigilance opposite party.
Yes.
As per your lordship's direction, I have filed a written notes of argument today before your lordship.
We'll proceed with the matter. I'll just run through the list, and then I'll start. So it will take little time, then we'll finish that.
So, my lord, it will be taken up today or some other day?
Just now there are a couple of matters. I'll just run through the list. Yes.
Item 15.
May I please?
If lordship permits, my lord, this is that matter, my lords. In fact, we both sat during lunch hour, my lords, to pinpoint, to find out the exact grievance of the petitioner. The petitioner grievance pertains to, my lords, release of sale deeds and the RORs, my lords, and also the passport, my lord. That was the 3 grievances, my lord. I pursued the matter and got the positive instruction with regard to the release of sale deeds and RRs, my lord. Lordship pass orders only, my lords, with the condition that he will not utilize these particular documents to dispose the property or for disposal or sale of the property. 1. And my lord, with regard, the 2. The third one is for a release of passport, my lords. Now, in this particular case, charge sheet has been filed, my lords, and the case is posted for framing of charge. But in this case, my lord, the petitioner's son, Dr. Sri Abhijit Das and daughter-in-law Rosaline Padis, they are residing at England, my lords. The intelligence report said that they are they're exploring the feasibility of going abroad. So it will not be convenient for the prosecution to ensure their presence at the time of framing of charge, my lords. So what I suggest, my lord, with regard to the 2 grievances, my lord, on that release of sale deed and RORs, my lords, lordship pass orders, my lords. Only the condition may be imposed, so they should not misutilize it in disposal or the sale of the properties, my lords.
The daughter and son of this.
Let's say Mr. Abhijit Das and daughter-in-law, say Rosalind, reside in England, and charge sheet has been filed.
Yes, there is flight risk.
My lord, with the condition to approach the court while going for the abroad, that any strong conditions may be.
Whenever you want to go, you move application. Your passport will be released.
That
Permission will
is
be
a
granted.
time-taking procedure.
And see, your passport is safely kept by them. Why do you worry? Whenever you want to go, I'll observe that. Whenever you want to go, you move application. If the court apply mind and they'll release the passport and allow you to go abroad.
My lord, that's your lordship, please.
What will you do with the passport?
My lord,
That passport is required when you will travel. Okay. For traveling, in any case, you have to move an application before the court. If the court allows you, then the passport is obviously going to be released. That time they will release it. Why do you worry? And you take back your sale deed and all.
Sale deed
All
and
the
RORs.
original documents.
All the original documents
And,
subject to condition that you will not carry third party interest.
My
Not that today you take it and sell it to someone.
But she is stepping the shoes of my colleague, my lord. That's why, my lord, I pursue the matters.
Silently observe it. Give me this.
So yesterday also, my lord, see, for the first time, my lord, was arguing that matters, that release of the bank account, your lordship,
Yes, yes.
property, my lords. See, you also discuss with me that this is my first case in all this thing. Your lordship, this was the matters, all right.
Now it is second case.
No problem. Now she stands in the shoes of Mr. May I submit
Yes,
the
yes. I am tempted to tell you a joke. One lawyer was arguing like this in a bail matter. He said that court said that whenever you join the bar, then that lawyer said that today only. The first case, then I must give you the bail. And a seasoned lawyer like Mr. Ragada appearing the next matter, I says that, my lord, this is my first matter. Then he said, the first matter you are suggesting, no, first matter in this court.
True.
Yes. In the present petition, petitioner is assailing the order dated 7/11/2019, passed by the special judge Vigilance in Vigilance GR case number 35 of 2018, whereby his application for under section 457,
correct.
application under section 457 CRPC has been rejected. But you are asking for release of amount of 2.50.
My lord, that is at the time of seizure, that amount, any
But
indemnity amount, that amount
our
might be-
grievance is now pinned with these particular documents.
So you
That-
said it's only document, but see in the prayer, he says that release 2.50 lakhs, nothing else. Just see the prayer.
No, in fact, that in that petition, he has
The release of the amount of 2.50 lakhs and all the documents. Okay.
all the documents.
What
She-
about
she
2.5?
showed me all the sale deed and ROPR.
What about the 2.5 lakhs?
On that, my lords, because our grievance is confined to this particular, my lords, I got instruction.
On what indemnity for that amount?
No, not bank guarantees, my lord.
Bank guarantee.
Both are doctors.
Right.
Both are talk.
Rejected. In the application, where is the application, madam? Yes. In the
Sure,
application, where is the application?
Next one, my lord.
Page.
Page application. What are the documents?
First page.
My lord, lower court 457 petition or?
Yeah, 357 application you have not moved.
जोड़ा मैं देखूँ तो ले जोड़ा sale date पे लिखा है जोड़ा.
That is Annex 3, my lord. Annex 3. It's 27 to 34.
Which are the documents you seek release? Where is the least?
My lord, para 7, my lord.
Para 7 up?
Page number 30.
30.
My lord.
Para 7. This is what in the application under, no, here, in the application under section 3, 457 CRPC, the petitioner inter alia contended age under para 7 code. Next, in essence, the petitioner is seeking the release of all the original documents.
Sale deeds, particularly.
Sale deed, etc., as mentioned in the preceding paragraph.
Also mention the ROR also. ROR sale deeds too.
And the passport as well as release of 2.50 lakhs seized from the petitioner. Seized from the petitioner bank.
On the petition.
Cash of 2.50 lakhs seized from the petitioner. Mr. Das, learned counsel for the Vigilance, from a short instruction from the department and the placed it on record the written instruction dated 22/7/2024 reads as under para 2 and 3. Para 2 and 3. Mr. Das further submits that insofar as the release of, insofar as the original documents like sale deed, ROR, etc. are concerned, the same may be released in favor of the petitioner, subject to condition that she shall, the petition shall not create the third party interest.
So not utilize it for sale or disposal.
Third party interest by either selling or disposing of in any manner whatsoever.
Properties.
Any manner whatsoever. Insofar as release of the cash security of 2.5 lakhs is concerned, he submits that the same may also be released subject to petitioner furnishing bank guarantees
of the equal amounts.
Equivalent amount. Insofar as the release of the passport is concerned, I am of the considered view that Mr. Das further submits. Mr. Das opposes for release of the passport on the ground that the son and daughter of the petitioner,
daughter-in-law,
son and daughter-in-law of the petitioners are
staying abroad.
Abroad, and there is a flight risk.
And intelligence report is that they are exploring feasibilities.
Intelligence report indicates that there is flight risk.
They will flee away.
Therefore, he opposes for release of the passport. However, I am of the considered view that the petitioner,
as and when
seeks to travel abroad, he may move appropriate before the court below, and the application will be considered at the on its own merit by the court below. With this observation, the petition is allowed.
I'd supply the copy of that instruction.
Much obliged.
You got all the things. Yes.
16 May, Prem Lords, did it come after lunch, my lords?
My lords, next week, any day, your lordship.
What is this matter?
Discharge.
And your lordship, last occasion directed whether charge in the meantime. If
No, not framed. I have taken instruction.
But the case was posted, my lords. So
Not framed.
not framed, lords.
Then
Here the wife, lords, they was posted to
next
1st May 2023 for framing of charge. my lord.
next week.
ठीक है, ठीक.
Yes. 17.
May please, your lordship. Your my lord, the appellate court confirmed the my lord sentence under section 307(149) and reduced the my lord the sentence from 7 years to 3 years. And thirdly, my lord, the prosecution examined 15 witnesses. Out of 15 witnesses.
Are you aiming at acquittal?
So far, my lord.
I'll hear you. That's
No.
I'll put it in the.
Not possible.
Huh?
Not possible.
Na hearing रे रखंतु काहे कि ना सेतरे आमे डिफेंस साखी देइछु दीटा that was not considered by the both of the trial court and the appellate court, and so far the eyewitnesses concerned, my lord, PW2 is the eyewitnesses which is partly blind, that was not considered. So far, my lord, the defense witnesses are concerned that they said that, my lords, the injury they were also present in the spot, my lords, and they have seen the occurrence. The prosecution not added them as in witnesses, charge-sheeted witnesses. Therefore, my lords, the defense side, they became the witnesses.
Then it is an arguable case.
Arguable case. 3 years or reduce.
Weekly get ready.
ता भितर मु दे देबी.
Next.
चेष्टा करी जदि हेगला हेगला नले पियो एक तो अछि लॉर्डशिप विल कंसीडर.
307 is confirmed. How it will be?
Confirm is
307 little difficult. Let us see. Yes.
Item 18. That's next week.
Item 18. Weekly list. Yes.
That's item 18. The appellant has been convicted under section 354 and
I know you would be asking for adjournment, but it's good start. Good, yes. Convicted?
Convicted under section 354 and 448 of the IPC,
Yes.
and sentenced to undergo SI for 6 months for the offense under section 354, and sentenced to pay fine 1,000 for the offense committed under section 448, and in default of to undergo SI for 15 days.
Yes.
That's the occurrence has been
What is the substantive sentence then?
6 months.
6 months, okay.
That's the
Ready,
occurrence.
ready for argument.
Let's-
Ready?
let's-
Okay. I'm passing it over, get ready. And period undergone also, you check it up.
Yes.
I'll hear you.
Yes.
Today only, yeah?
Yes.
Yes.
Item 19.
May I please, Lord? Is the conviction of simple imprisonment of 1 month under section 323 of the IPC, my lord. Initially, the petitioner was facing trial under section 307, 324, 506, and 34 IPC.
Yes.
But all the charges were disbelieved by the London Trial Court. But I subsequently come to a conclusion that conviction under 323 is made out. Accordingly, convicted for simple imprisonment of 1 month. My lord, here, my lord, some discrepancies are there in the statements. Basically, 8 witnesses were examined by the prosecution. Out of the 3 witnesses, the London Trial Court relied upon P11, P55, and P6, my lord.
Yes.
P11 is the witness who was there at in the spot, so was considered as eyewitness to the occurrence. P55 is the doctor, and P6.
What is the period undergone?
My lord, there is no period undergone. He was all along bail in the.
307, you got the bail immediately.
My lord, there is an anticipatory bail. On surrendering, he may be released on bail. This was the direction. So on the date of surrender, he was released.
So substantive sentence is 1 month.
1 month. And age of the petitioner as of now might be 60 years plus, because at the time of presenting this revision, he was 47 years.
2011.
2011.
I'll give probation.
And you are
23, what to do? 1 month sentence.
1 month.
In the late 60s.
Miller.
Why should you send to
Miller.
उपयोग कर दे दे दिया मत देनी पड़ो I'll just take it up 5 minutes. Mr. Moon, just 5 minutes. What do you want?
Rejection of discharge petition has been.
Item 2.
No, charge has been framed, by now.
No, rejection of discharge petition.
Item 2.
Charge has been framed.
Charge has been framed.
Weekly list, no.
Again.
Supplementary. Where is the supplementary ticket?
Se to be prepared nanti.
Yes.
State.
What is this matter is about?
Against framing of charge.
Yes.
Against framing of charge.
And that too, my lord, vigilance inspector is involved.
I am not for the vigilance.
Telephonically, she called another person, collected. Demand was 20 lakhs. Reduced to scale down to 10 lakhs.
Non-stop chaliwa.
Oh, kindly carry on.
I admit, se vigilance inspector ko bhi bahar kar dele. I am a private party.
You are not a business.
No, I am not a young boy. Let there be stay. You let it come and any other thing.
Stay nahi hoga.
Stay question.
No, petition file.
No. You argue matter. I'll put it tomorrow, day after. But no question of stay. No.
No. I will file a petition.
Only because of that only we are suffering. The matter is in the charge. Pending since last 20 years.
Kali ki pardon asu theek hai.
That I comment.
Again.
Put it tomorrow, day after tomorrow.
Thank you, sir. Time lagi.
No, sir. Take Monday.
Okay, no problem.
Monday.
Till then, stay.
No.
Still about trial Korea
See,
time.
I will tell you, there are matters pending since 2011 where only adjournment will be sought. That is the order. Application is moved, adjournment will be sought. Charge matter pending since 2011.
ଆପଣ ତ ଆଜ୍ଞା ବହୁତ ରିଭିଜନ ସାରି ଦେଲେଣି
I
ଭଲ
want
ଭଲ 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 ଭାବରେ
ଭଲ ଖରାପ what that difference.
ନାଇଁ 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 ସମସ୍ତେ satisfied ଅଛନ୍ତି।
No, but you argue Monday.
ଆଜ୍ଞା
Monday.
ଆଜ୍ଞା
If you have a case, I'll discharge straight away.
ଆଜ୍ଞା
Why are you unnecessarily
ଆଜ୍ଞା
putting it? And get that order where the vigilance inspector has been discharged.
ସେ କହିବେ ଯେ ମାନେ ଜାଣିଛନ୍ତି he knows well.
He is a private person. So be ready with that. Yes.
No, in fact, there are two judgments also led supports to.
Let us see if the.
I am thankful that now he is supporting me.
No, not supporting that, sir. This is truth.
Slowly he'll support you when you are asking. Yes.
14 mile.
Mr. Panigray was appearing for senior counsel. Yes, sir. Oh, hard copy.
Lordship, this is against the order of framing of the charges for the offences under section 13(2) read with 13(1)(c) and D of the Prevention of Corruption Act, sections.
Are you going to refer to this big volume?
I will. But the specific page, etc., I will
No, that's right.
tell Lordship, so it will not be problematic.
I can see through this file.
Lordship. And the offences under the IPC are Lordship 420.
1 minute.
Argument curriculum. 80.
आगू भी इठी था इधर स्पेस ठीक है इतने पक्कों को आना keep it so that I can write this. Yes, sir.
Lordship. The offences are Lordship 13(2).
Yes.
Read with 13(1)(c) and D of the Prevention of Corruption Act 1988, and the offences under sections 420, 409,
yes,
468, 379, 411, and 120B of the Indian Penal Code.
Right.
These are the offences of which I am being charged. Now, Lordship, the allegations leading to the framing of the aforesaid charge is that, Lordship, on 27/7/2013, an FIR was lodged against the present petitioner and others, including officials of the mining, forest, and revenue department of the state, alleging illegal mining and removal of iron ore from the revoked mining lease area of one Jagdish Mishra and areas of Uliburu Reserve Forest, Lordship. It is alleged in the said FIR that a vigilance inquiry was taken up relating to the working of mining lease over an area of 56.94 hectare in village Uliburu under Champa subdivision in the district of Keonjhar, granted by the government of Orissa in favor of one B.K. Mohanty, who is a co-accused in the case. The lease was granted by the Mining and Geology Department on 7/1/1982 for an area of 56.94 hectares in village Uliburu.
There are how many accused here?
There are 19 accused.
29 accused persons.
29 accused.
28 accused.
Lordship.
28.
And the lease was granted for a period of 20 years, Lordship, by mining lease deed executed on 13/12/1983. As per the aforesaid lease, after the lease, surface right was granted in favor of the lessee as regards 28.24 hectares of land, and thereafter
Lessee is that BK
lessee is that BK Mohanty.
BK Mohanty, sorry.
As I pointed out, Lordship.
That is accused A7.
A7.
17.
17.
Hmm.
And was obtained from the collector on 22 to 1984. Thereafter, the lessee submitted a report to the government on 18/11/1999, making a prayer therein to surrender his mining lease due to depletion of saleable grades of iron ore. The aforesaid application filed by the lessee for surrendering the mining lease was not accepted by the government, and accordingly, he withdrew the application on 18/11/99, filed the 14/5/2002. He filed the application that he will continue with the mining operation.
What is the date? 5?
Lordship.
What is the date?
Date is 14/5/2002. He filed the application stating that he will continue with the lease.
Withdraw the earlier application of
Withdraw is 18/11/1999.
Yes.
To surrender the mining lease.
Yes.
Then he resumed the mining operation, which was valid till 12/12/2003. The mining lease was granted on 13/12/1983, Lordship. Lordship got it for a period of 20 years. 13/12/1983 for a period of 20 years.
Okay.
So it was valid till 12/12/2003.
Yes, right.
Then he filed an application for renewal of the lease before the government, to the government through the collector Keunjhar. He filed the application on 3/12/2003. 2003, Lordship.
Before expiry.
Before expiry of the lease.
That's the requirement.
But no, that is not the exact requirement. The exact requirement is that 12 months prior to the expiry of the lease, he is required to file the application for renewal. And once the statute says that once the renewal application is filed, the lessee continues with the deemed renewal.
Deemed provision.
Deemed renewal, that is. And so, although he did not file it in time, he filed it before the expiry of the lease with an application for continuation of delay on ground of his illness, the original lessee. Then I come to picture. After this renewal application is filed, thereafter the original lessee executes a power of attorney.
When?
In favor of, the power of attorney was executed on 29/12/2003.
Okay.
29/12/2003 in favor of.
That day it was expired. Indeed, 12/12/2023 it expired. Lease expired.
Prior to the expiry, he had already submitted the application.
Then 9 days before you have applied.
And on 29/12/2003, he executed a power of attorney in favor of one company, Mr. Snehapus Marketing Private Limited.
Snehapus.
Who is also an accused. The company is also an accused therein.
Who are you in that?
I am one of the partners. Director of that company. I am one of the directors of the company.
All the directors are
two directors.
Okay.
Two directors, I am one.
Who all are they? Director?
Director one is Deepak Gupta, and the second one is Champak Lal Gupta, the younger brother of Deepak Gupta.
Okay. Yes.
And so, it is stated that the Deputy Director of Mines, in connivance with his subordinate officials and others, fraudulently and dishonestly allowed the lessee to carry out the mining operations since January 2004 and permitted dispatch of iron ore from the said mines, even though the mining lease had not been renewed. This is the allegation made by the Vigilance in the FIR.
Okay.
And it is further alleged that in the FIR that the mining plan, as per the statutory law, before somebody does mining, the mining plan is to be approved by the IBM, Indian Bureau of Mines.
Yes.
So herein it is stated that the mining plan was submitted
Submitted, not approved, huh?
no, it was submitted and approved. Approved on 17/9/2004.
17?
9/2004. And so it is alleged that from 16/1/2004, from which date I had shown production of the ore, till 16/9/2004, to 16/9/2004, the mining operation was done without any approved mining
From
plan.
16/1/2004 to
16/1/2004 to 16/9/2004. The mining plan was approved by the IBM on 17/9/2004.
Okay. Yes.
Then it is also alleged in the FIR that the present petitioner, in connivance with the lessee and officials of the mining, forest and revenue departments, fraudulently and dishonestly resorted to illegal production of iron ore to the tune of 47,48,826 tons beyond his mining lease area.
Yes.
That is in the area of the lapsed mining lease area of one Jagdish Mishra and Uliburu Reserve Forest. I am repeating, Lordship, this is important. The allegation is that the production of the ore is in the official records, Lordship. How much of ore was produced and how much of ore was taken out. It is to be reported to the department in accordance with the law. So the figure is worked out in the FIR like that. And further it is alleged that the mining operation was done by this power of attorney holder of the lessee in the lapsed mining lease area of one Jagdish Mishra, from whom it is alleged that I had also taken another power of attorney.
One is BK Manti, another is Mishra.
And the adjoining another mine holder, the mining lease area of BK Mohanty and Jagdish Chandra Mishra, and the Uliburu Reserve Forest, which also adjoins the mining lease area of BK Mohanty. And it was stated that this was the illegal mining I did, and thereby I caused a loss of rupees 839 crore 67 lakh 11,748 to the public exchequer. And thereafter, the FIR was registered alleging commission of offences under section 13(2) read with 13(1)(c) and D against the public officials, and under sections 21(1) of the Mines and Minerals Development and Regulation Act 1957, alleging that there was illegal mining, and under section 3 of the Forest Conservation Act 1980, alleging that there is illegal mining in forest land, there is encroachment of forest land and the removal of product, and under sections 120B, 420, 379 and 411 of the Indian Penal Code. This is the FIR, Lordship.
Yes. So 420, 411 and
120B, 420, 379 and 411 of the IPC. Lordship. Thereafter, after the registration of the FIR, Lordship, the investigation was taken up, and on completion of investigation, first a preliminary charge sheet was submitted, and thereafter another supplementary charge sheet was submitted. And it is alleged in this charge sheet that Jagdish Mishra, after alleging illegal mining in his area, in his last mining lease area at Uliburu on 18/3/2004, and without heeding to the request of the department for a joint physical verification of the boundary, he executed a power of attorney in favor of the present petitioner.
Jagdish Mishra is also an accused, or
Jagdish Mishra is not an accused. I am verifying, Lordship, subject to verification.
Finding his name anywhere. He is cited as a witness against you. Jagannath Mishra is there.
Jagannath Mishra is there. Jagdish Chandra Mishra, I don't think is there.
Jagdish is there. 18.
18.
Yes.
Okay.
Yes, he's there.
Okay, Lordship. Lordship, it is stated that Jagdish Mishra,
both the leasee along with you and your other director and company.
as regards Jagdish Mishra, I am making the position clear. What has happened in Jagdish Chandra Mishra's, so far as the leasehold area of his is concerned, although the lease was granted, there was never any environmental clearance. He did not get any environmental clearance. And accordingly, there was no surface right was given to him. The land was never delivered to him by the government because surface right could not be given.
Still, he has given a power of attorney in your favor.
Lordship, may kindly see. And accordingly, the lease had been cancelled.
Right.
And so his giving of the power of attorney is of no consequence. And it is further alleged in the FIR, Lordship, in the charge sheet.
But on the strength of this power of attorney, which you are saying that there is no consequence, you started operating there. That's the allegation.
No, that's not the. They also admit that any mining operation in the land of Jagdish Mishra by anybody is illegal.
But have you done or not?
I have not. I have not. I will come to that. That is why. That is my case. And secondly,
the power of attorney was executed in your favor.
Yes.
You had no knowledge about the
surface right.
Yes.
I was moving the power of attorney. By the power of attorney, I was moving for getting the environmental clearance and for revival of the mining operation by Jagdish Mishra. That is why the power of attorney was given to look after his.
Is there any recitement to that effect in the power of attorney that you will be doing it, all these things?
All things relating to his lease.
No. Lease right is, in the power of attorney. What are the recitement? Whether there is any recitement in the power of attorney that yes, there is no environment clearance and all, and you will go and do it. Was he
all works relating to the mining. So that includes all.
No, that the recitement of power of attorney will
A recitement of power of attorney does not say that I will do mining.
Then you knew that there is no
Yes.
environment clearance.
Yes.
Still you enter into power of attorney. Then
Yes.
On the strength of that you attempted to
For doing his work. For doing his work for which environment clearance could not be obtained and the mining lease was cancelled. So I was trying to revive that. And that is why I had taken the power of
you were
attorney.
trying to revive, it's all right. Whether in the power of attorney was it is there any recitement to that effect that there is no mining, there is no environment clearance at all, and I am giving you authority to do well to see that
The Lordship, the power of attorney,
yes.
The power of attorney is given by the lessee, Jagdish Chandra
I
Mishra,
understand that.
who knew that surface right has
I am
not
asking
been.
whether you knew or not.
Yes, I also knew.
So why have you entered into power of attorney then?
Power of attorney I went into because I thought that I will clear his papers.
Whether in the power of attorney it is written that it is not there.
It is although not specifically written, generally it is written that I will look after all the works relating to
If you don't have
the
right,
lease.
you don't have anything. What
Lordship,
kind of power of attorney is it?
Lordship, we will come to that.
Yes.
Lordship. That aspect we will come soon.
Lord,
Then, Lordship,
Lord, I am not disturbing your Lordship. Wanted to know whether Jagdish Mishra is an accused or not.
Yes,
He was
yes,
accused. Yeah,
18.
accused of 18.
Yes, I have seen that. I have
Yes.
seen that. Thank you, sir. Yes.
and the allegation of the prosecution is that the allegation of the prosecution, the state vigilance is that by means of the power of attorney, I entered into the land of Jagdish Chandra Mishra and did illegal mining, which I say that I have not done any illegal mining. I have not done any mining at all inside the leasehold area of Jagdish Chandra Mishra.
And you have done it for BK Mahathir.
I have done it for BK Mahathir only on the area of which I was given power of attorney. That's my case, Lordship.
But there was
then
no approval from 16/1/2004 to 69/2004.
IBM.
IBM.
IBM renewal, Lordship, IBM renewal post facto.
Post facto.
Post facto. It
Yes.
covers that period. It covers the IBM renewal. Lordship will find from the report.
I know that. Part.
The IBM.
So therefore, getting clearance subsequently is neither here nor
Yes. So that also doesn't hamper. Then the next allegation that is alleged in the charge sheet against me is that although initially in the FIR, the production was given at 47 lakh and some thousand and some tons ordinary fast in the FIR. In the charge sheet, they revised the figure, put it at 65 lakh ton. And they stated that although I had raised more ore from the land in question, I had reported to the department only 47 lakh this much, and thereby I concealed an amount of 19 lakh and odd. And they say that I have a sister concern, which is called as the Deepak Steel and Power Limited, another steel factory. And that steel company, manufacturing company, they allege that the ores, the excess ores, I supplied clandestinely to that Deepak Steel and Power, and thereby they received that product, and they have shown by receiving that from some Fixus farms which are not in existence. And thereby they say that Deepak Steel and Power is guilty of the offense under section 411 of the CRP, of the IPC. Deepak Steel and Power. That's the allegation.
Where is Deepak Steel?
At that place.
No. Yes, 25.
25.
25. But you are not holding the brief of Deepak.
No, Deepak Steel and Power, no. The MD is representing that company.
Who is MD?
Deepak Steel is also of this Deepak Gupta.
Haricharan Gupta.
But you are not arguing for his case.
No.
It's all right. Yes.
Then, accordingly, they have computed, and as regards the prosecution under the MMDR Act and the Forest Act, I pointed out to my lord at the beginning that prosecution under the MMDR Act and Forest Act was there in the FIR. Those sections were there. And in the charge sheet, while filing the charge sheet, the Vigilance Department stated that separate prosecutions relating to illegal mining and separate prosecution relating to illegal mining in forest land have already been initiated by the respective departments in the court of the magistrate, which is competent to take cognizance of the offences.
Yes.
So those sections were dropped from the charge sheet. And
That
in
is
the charge sheet,
21(1) and section 3.
3.
Yes. That is dropped.
4, section 4 and 21 of the MMDR Act and 3 of the Forest Act.
Yes.
And in the charge sheet, the sections for which I am sought to be prosecuted are 13(2) read with 13(1) C and D of the Prevention of Corruption Act, section 409, 420, 468, 379, 411 and 120 B of the IPC, Lordship. And charges have already been framed under these sections. My grievance is that the learned special court has framed charges against the petitioner on the aforesaid sections of law, although there is absolutely no material on the records of the case to constitute the ingredients of this act.
Which one? 4940?
All the sections I have impugned, Lordship. And before I come to the allegations against the petitioner and the charges that have been framed against me, I will first submit regarding the position of law on framing of the charges. The position of law as regards the framing of the charges is that, Lordship, there must be some material implicating the person accused of the offense that he has committed the offense. The material may not constitute a prima facie case even. The material may create a grave suspicion, not a mere suspicion, but a grave suspicion, warranting the framing of the charge. The material may not be sufficient to hold him guilty of the offense, which can be considered at the time of the trial. However, there must be some material to assume that strong suspicion lies against the person concerned for whom charges are to be framed. The learned court.
Some material, no material, insufficient material.
Yes, Lordship. The learned court cannot act as a post office of the investigating agency.
Are you pitching your case to a case of no material or insufficient material?
Absolutely no material.
No material. Yes.
And the relevant portions I am pointing out, Lordship. I'll do. First, Lordship may see the citations that I had given.
No, I think let us see the materials which you have according to you. Thereafter, the law is clear on that.
Okay.
That
The
we
law
cannot
part.
favor on the law part will.
Law part. Okay.
Let us
Okay. Lord.
understand the facts
Okay.
first.
Okay. Okay. Lordship.
Yes.
Okay.
Law will
Okay.
take it up.
My humble submission is that, Lordship, coming to the material against the present petitioner, the basis for the entire case is the fact that there was a joint physical verification prior to the lodging of the FIR. And it is alleged that such verification revealed that there was mining outside the lease area, from which it is assumed that the petitioner had done illegal mining with a dishonest intention outside the leasehold area.
Yes.
Such assumption is completely unfounded. This is the basic allegation, Lordship. There was a joint physical verification. Officials of the Vigilance Department went to the spot, and local mining officials were called, local revenue officials were called, and local forest officials were called, and joint physical verification of the spot was done. It is alleged that the said joint physical verification found during the said joint physical verification, it was found that I had not conducted any mining inside the leasehold area of BK Mohanty, of which I was given the power of attorney. Whatever mining I had done was either in the lapsed mining lease area of Jagdish Chandra Mishra or inside the reserve forest. This is the allegation. I say, Lordship, that this allegation is completely unfounded. The reasons of my saying so are...
If you would have done the mining activity in the BK Mohanty's area, there would not have any case against you. Since you have done in Jagdish area and the reserve forest, then only the case is...
Lordship, why I say, Lordship, now that why that allegation is unfounded. Lordship will see that the lease deed was executed, as I pointed out to Lordship at the outset, on 13/12/1983. And the leasehold area was demarcated and handed over to the original lessee in the year 1984.
Yes.
The petitioner by then was nowhere in picture. And
you came in picture in 2003.
And whatever quantity of mining operation the original lessee was doing was in that land, the land which was given to him. And the petitioner came into picture on 29/12/2003 when the power of attorney was executed by the lessee, that is the accused BK Mohanty. Therefore, the petitioner can by no stretch of imagination be said to have any idea that the leasehold area on his own, he had to go by the area pointed out to him by the original lessee.
Yes.
And it is elementary that the officials of Geomin surveyed the lease area in order to prepare the mining plan. Geomin, Mr. Geomin is the agency which I had employed for preparation of the mining plan. And they have prepared the mining plan. And the IBM approved my mining plan. During the mining operation, the IBM is required to inspect and verify that mining operation is done according to the mining plan every year. It is mandatory under the statute. And if there is any deviation in mining, if there is any illegal mining, then IBM is to point out that. And they can even prosecute. And in this case, this alleges illegal mining from the beginning of 2004 till the year 2000. 2009. So during all these years, neither the state mining department pointed out that there is any illegal mining.
Because they are the co-accused with you.
IBM is not prosecuted.
No, the state mining also.
State officials, some of them are prosecuted, but not a single official of the IBM is being prosecuted.
Right.
Who is to approve the mining operation and the mining plan. So my contention herein is that, Lordship, that I had intentionally done mining operation beyond the leasehold area of BK Mohanty is completely false. By the time I had come to picture, there was already mining. And further, Lordship,
From 1984 to 2003.
2003. And I did mining in that area, the area of which the lessee pointed out to me.
And
Because I was nowhere.
IBM shown it to you.
And that which was verified by the IBM. In such view of the matter, Lordship, no criminal intent can be attributed to the present petitioner, even if it is assumed that the petitioner's case as to mining is outside the leasehold area of BK Mohanty. Then, Lordship, in the charge sheet dated 24/6/2014, which is at page 284 and 285 of my documents, document jota diya hai 284 and 285 of the volume of documents that have been supplied.
Yes, 284. Yes.
Lordship, 284, 287.
Yes.
Lordship got it?
284.
Then I am pointing out. The
By what
last
stage
para.
of the trial, by the way?
Lordship?
Stage of the trial?
Stage of the trial, out of 100 status report my learned friend has filed. Out of 178 witnesses, 53 have already been examined.
Well, I have filed a status report in my written note today.
Why are we laboring in this then?
Lordship, absolutely no case is made out. If the matter could not be taken up earlier, how can I be faulted, Lordship, for that? All there.
Okay, anyway.
Lordship, to page.
Public hearing, I filed an application, but never listed.
What to do? You know the problem.
Lordship.
Yes.
Page 284, Lordship.
Yes, 284.
284. Last para.
Yes.
Sri Deepak Gupta, power of attorney holder of BK Mohanty, has submitted mining plan, modified mining plan, and scheme of mining to Indian Bureau of Mines, Bhubaneswar, which has been approved by Regional Controller of Mines, 15/12/2004, 14/09/2007, and 5/08/2009, respectively. The mining plan scheme has been prepared by Messrs. Geomin Consultant on the consent letter issued by Sri Deepak Gupta, power of attorney holder of BK Mohanty. Then please turn over, Lordship, to the next page. Investigation revealed that as per provisions of Rule 13 of Mineral Conservation and Development Rule 1988, the mining operation is to be in accordance with the mining plan. It is found that the officials of Indian Bureau of Mines, Bhubaneswar, have conducted MCDR inspection of the said mines on different occasions. It is mandatory to visit the mine site while conducting MCDR inspection. The inspecting authorities are to furnish information in compliance of terms and conditions of lease deed in Part 3rd of prescribed standard form relating to performance of mine owner. Further, the inspecting authorities are to submit a proposal in Part 4 of the prescribed standard form to state government for taking action in case of illegal mining, mining dispute, etc., as required under Section 23C of MMDR Act 1957, unquote, Lordship. So, from this it is evident, Lordship, that in the charge sheet, there was inspection by the officers. It is mentioned that there was inspection by the officers of the IBM, and they have never ever pointed out any irregularity, much less illegality in the entire mining operation.
Yes.
So, Lordship, it may kindly be borne in mind that the officers of IBM have much more technical expertise and training than the vigilance authorities who have investigated into the case and who are associated as witnesses in the case. No expert has been examined during the investigation to buttress the claim by the prosecution that there was any illegal mining and the extent thereof.
Yes.
So this is the background, Lordship. Now we will come to the specific sections of law of which I am being charged.
What about Jagdish Mishra's area?
Jagdish Mishra's, Lordship?
You said in the Jagdish Mishra's area you have not done at all.
Yes, Lordship.
Where from you get it there? Of the charge.
That is there in the inspection report of the IBM.
Show me.
That I have not brought. I will file along with an affidavit.
The
Rejoinder
allegation is both the areas.
Yes.
Mahanti's area and
Yes,
Mishra's area.
yes, IBM.
Vigilance case is that there was no mining within the BK1 area.
And everything has been done in
Done.
Jagdish area.
Outside his area.
Show me that by affidavit. In Jagdish area, what has happened?
Yes. That is there.
Unless you show that, you have to, in so far as Mahanti's area is concerned, it's all right. There was inspection and all from 84 to 2003. Mahanti was doing 2003. You stepped into the shoes of Mahanti after the lease is expired, and you have done, and that is in conformity with IBM report and all. So therefore, the allegation might be wrong. That's right. But what about how will you get out of the Jagdish area? Maybe wrong allegation.
Jagdish.
How do I know, Millard? When
That is why the trial is.
Well, IBM prepared the mining plan.
No, how, where, I am not
I
interested.
have done
In the
my-
charge says,
and
I
that
need
is-
to know, whatever allegation is made, you have to separate the grain from the sap. Otherwise, how, what is the use of the,
That part
you have to clarify.
That part also will be clarified after we examine the ingredients of the offense.
Right. Let us see.
Let us see the ingredients of the offenses. First, I will take your honor to the charge under section 13(2) read with 13(1)(c) and D of the Prevention of Corruption Act.
Yes.
So far as section 13(1) of the PC Act deals with criminal misconduct against public servants. Section 13 is meant in the Prevention of Corruption Act is meant for the punishment of the public servants who are defined under the Act. And I will now take your honor to the charge sheet. So, Lordship, I will now take Lordship to the averments in the charge sheet regarding my description of my identity which has been there.
Yes.
Lordship will find from the charge sheet at page 104.
104.
Running page 104. Lordship got it?
Yes. 104. Yes.
104 of the documents.
Yes.
Lordship, name Sri Deepak Gupta, then father's name, then date, year of birth, then sex, then nationality, passport number, place of issue,
Yes, you are
religion.
private person.
Yes. Occupation, private person. I have been stated that I am a private person.
Yes.
Now, Lordship, I will show the offense under 13(2) read with 13(1)(c) and D. I cannot be charged. And in this regard, I place reliance in the case of Lordship, the state of SP through special CBI versus Uttam Chand Bora, which is at page, which is at page 19
Of the compilation.
of the compilation.
Yes.
Okay.
Yes.
Go to the file.
19.
Page 19.
Yes.
Page 19, the top para, Lordship. Page. Page
19, yes. Para 21.
No, from the top line. If there is no prima facie evidence or the evidence is totally unworthy, the duty of the magistrate by para 23, Lordship. Para 23. The factual at page 20. The factual narration in this case would reveal that Uttam Chand, the respondent, was not a public officer or public servant. He cannot therefore be charged with committing an offence under section 13(1)(e), read with section 13(2) of the PCA.
Yes.
So, there is absolutely no prima facie case as regards the aforesaid offence.
Yes.
He cannot be prosecuted of the aforesaid offence as he does not come under the category of public servant as defined under the Act. Now coming to the charge under section 409 of the Penal Code. May I take my lord to the charge which is at page 37 of the documents, annexure, which is annexure 1, charge under for 409.
37.
Page charge with 7 heads, Lordship, it is. Page 37, Lordship got it. Charge.
In the
Fourth-
paper book? In the paper book or compilation?
On the compilation of the documents.
Compilation of 37, yes.
Page 37, Lordship.
Page 37.
Charge with 7 heads, Lordship. Lordship may come to the last charge, fourthly, of that page.
Yes. Yes.
That, Lordship, I am reading out.
Mhm.
Fourthly, that you working as such during the aforesaid period and in such capacity entrusted with certain property, that is Uliburu ore mines, committed criminal breach of trust in connivance with the mining, forest and revenue officials and the lessee to conduct illegal mining in the lapsed mining lease area of Jagdish Mishra and Uliburu Reserve Forest, causing loss to the government to the tune of rupees 1,523 1523 crore 59 lakh 48,527.48 and thereby committed an offence punishable under section 409 IPC and with my cognizance.
But you are going with a presumption that you have not done anything in Jagdish area.
Yes, whether...
Show me you have not done anything in Jagdish area. Unless you satisfy me that in Jagdish area you haven't done anything, how will I proceed?
409.
409.
For 409 Miller, assuming that I have done in Jagdish area. Let us assume.
Yeah.
409 will not be attracted because I have not been entrusted with that property. Yet, what is the charge, Miller? You have been entrusted with property.
Whether
A.
validity on entrustment or not, because there was a power of attorney. There was a power of attorney that itself is entrustment.
No, let us say, what is the charge here, Miller? You are entrusted with property A.
That property A is entrusted because there was a power of attorney. Through power of attorney, you got interested yourself. Wrong power of attorney, right power of attorney.
No,
trial
that
is looking.
is different matter. That is different question.
You admit that there was a power of attorney executed by Jagdish in your case.
Jagdish was there.
That is the entrustment.
That is the prosecution case. That no doubt, no difficulty on that. But what is the charge here, Miller? Charge is that you are entrusted with property A and you have committed criminal breach of trust in property B.
No, that's not.
That-
No, Lordship, may kindly see the charge again.
Let us read it now.
Again.
Fourthly, that.
Again.
you are working
That's
as
why
in the
rereading,
period.
Lordship. That you working as such, you means in the first of it is described, Lordship. You as director of Mr.
Then you are saying that Oliburu or mine.
Yes.
What is mine?
Yes, entrusted with certain property, that is Ulivuru or mines, which is the mine of
Mahanti. Mahanti is mine. Okay.
Committed criminal breach of
Yeah, I
trust.
understood. Let us proceed now. Yeah.
Lordship. Now, Lordship.
Oliburu is the Mahanti's lease area.
Yeah, Mahanti's lease
where you
area.
say that in Mahanti's area you haven't done anything,
Yeah.
but in Jagdish area we have done.
You have done.
That is prosecution.
So there is no entrustment in so far as Oliburu is concerned.
Yes, Lordship.
Yes. Next.
Then, moreover, the most important fact, another important fact which I may kindly point out to Lordship, there is no allegation relating to 409 IPC against me in the charge sheet. There is absolutely not a single sentence of allegation is there relating to the offense under section 409 of the penal code. And secondly, Lordship, as my learned senior pointed out, section 409 IPC provides for punishment of the offense of criminal breach of trust committed by a public servant, a banker, merchant, factor, broker, attorney, etc. in respect of that property of which entrustment is done to him. In order to make an attorney liable for the offense under section 409 IPC, it must first be proved that there was entrustment of the property of which misappropriation is done. In this case, it is the case of the prosecution that the state government had not given surface right to Jagdish Mishra. The state government never delivered the property to Jagdish Mishra at any point of time. So the question of Jagdish Mishra delivering the property to me under the power of attorney does not arise at all.
Then you are making out a case of 468 against you.
468 also we will see.
Straight away you are conceding 468.
No. 468
Why
also will not be matter.
You knew that there is no entrustment by the government to Jagdish. Still you enter into a power of attorney and proceeded with whatever you want. Why have you entered into power of attorney at all, if that was the case?
Lordship, I wanted to do his
What was your
work
intention?
relating to mining.
What was your intention behind it?
Intention was to do his work. He could not get forest clearance.
That is
He
why
could
I am
not
saying
produce
show me in the power of attorney whether there was any recital to that effect, that there is the area was not given to me. Still, I am giving you power of attorney. You get it clear and do it. If that recitement is there, then you are out from 468. Otherwise, you are in 468.
No, Lordship, one thing may I point out, Lordship.
Maybe I am not able to.
Lordship, may I convey one thing here. Lordship, everybody knew, including the lessee Jagdish Mishra, that their mining operation has not been authorized in his land.
So therefore, show me the power of attorney. What was the recitement? You are operating in the mining, and you know a mine which is not
as I at the outset, as I pointed
by the government. Still, you are taking it over.
Before that, let me first complete with these sections. Then I will deal.
You go in your own pace.
Yes,
So
Lordship.
I don't want to interject in between. Yes.
Then, Lordship, may I point out to Lordship a position of law in a decision which I have cited?
Yes.
The relevant portion.
409.
409.
Yes.
Here page.
Page?
Huh? Bus sir. 34 of the
page 34?
Submission, 34 of the citations. List of citations I have, page 34, running page 34.
Yes. Yes.
The case is Ashok Basak versus State of Maharashtra and others, 2010, volume 10 SCC 660.
Yes. Para?
Para is 21. Lordship got page 34.
Yes, I got it.
21.
Yes.
21, Lordship. It is plain that
One-
for
para
constituting
21?
21, I am reading
One
out.
minute.
It is plain that for constituting an offense of criminal breach of trust, the following ingredients must be satisfied. A person should have been entrusted with property or entrusted with dominion over property. B, that person should dishonestly misappropriate or convert to his own use that property, or dishonestly use or dispose of that property, or willfully suffer any other person to do so. C, that such misappropriation, conversion, use, or disposal should be in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract which the person has made touching the discharge of such trust.
Yes.
So, by entrustment, what the law requires is that, Lordship, the accused should receive the property and hold it on behalf of another. Somebody, the original owner, gives the property for some particular purpose or to guard the property. He delivers the property to another person. That person has the control or dominion over the property. So a trust is created. And when there is a breach of that trust, somebody misappropriates.
Imagine a situation where a government property is there. You create a document for that government property, and that document is entrusted to someone else. What will happen?
There is no
entrustment.
entrustment. This offense will not be made out. Some other offense may be made out. A theft might be committed, but this offense, because the person who has made over the property,
You say that
is not the original owner.
legally valid entrustment has to be there.
Yes,
In
yes.
order to bring
Yes,
409.
yes.
That's
The
what it-
person who is the owner must give the entrustment.
That means in this case, if the government would have entrusted you, or the entrustment by the government to Jagdish would have been valid, then
only
in turn that entrustment would
then
have been
only
valid for the
it would
purpose of
have been.
409. That's what he
Lordship,
wants.
Lordship.
Yes.
Your
Yes.
reference. এটা নেই তুই সেটা বাদ করি reference কি রঘুনাথ
But how will you explain this? Entrusted with dominion over the property.
entrusted or dominion over the property. The question of dominion over the property.
Jagdish had dominion.
Jagdish had no dominion.
But
property had not been given to him.
But lease was there.
Lease does not create any right over the property. Lease only speaks about the terms and conditions, how you will perform the mining operation. After surface right is given, then only possession of the land is delivered. That is no.
That part you have to show me.
Yes, yes.
Whether valid entrustment to
Yes,
Jagdish was there or not.
yes, Lordship. It a card.
Yes.
It a card. Page kete.
Yes, 409 is over. Next.
The other aspect in 409.
There are other aspects.
As stated in the charge, the property entrusted is visible to another. And misappropriation of criminal breach of trust in respect of some
I
other
understand. That I
It
understand.
is Raghunath.
So this cannot.
But see, I tell you, these are the police vigilance has narrated the facts. But what are the documents speaking? Merely because in the narration, in the charge sheet, if there is a typo, suppose.
No, this
in
is
place
the,
of
this is the charge framed by the court.
No, he has pointed out the charge sheet. I have not seen the charge yet.
Charge sheet, there is no allegation of 409.
No, the page, which page you have shown me right now? 37. Page 37 is the charge sheet.
No, charge framed in the court.
Okay, this
the
37. 1
original.
minute, then let me see.
This charge framed by the court.
Okay. Then you have it.
which is under.
It is under challenge, at charge.
Application charge. Huh?
Lordship, may kindly
Yes.
come to another citation which I have given. P. Raghunath Patra versus State, which is reported in 1977, volume 44, CLT 31, a decision of this honorable court. May I take my lot to directly to the relevant portion?
Page.
The decision runs from page 39. Decision runs from page 37, Lordship. Lordship, may kindly come to page 39 of the citations.
Page 13, eh?
Lordship.
Page 31,
Lordship.
no,
After the
77.
second para of that page, it follows almost axiomatically from this definition that the ownership of beneficial interest in the property in respect of which criminal breach of trust is alleged to have been committed must be in some person other than the accused, and the latter must hold it on account of some person or in some way for his benefit.
Yes.
Then, in Vajir Raghavji Patel versus State of Maharashtra, it has been held an owner of property in whichever way he uses his property and with whatever intention will not be liable for misappropriation.
Yes,
And
I got it.
It this was.
Let
This
us
was
proceed to the next.
Lordship.
Yes.
Then Lordship, for constituting the offense of the property must be entrusted. This is what I have submitted, Lordship. In the present case, the petitioner was given power of attorney by B.K. Mohanty and was authorized to raise ore from his mine and to deal with the ore. As per the case of the prosecution, no mining operation was done in the leasehold area of B.K. Mohanty, and the petitioner raised ore from the last mining leased area of Jagdish Mishra and Uliburu Reserve Forest. So far as the mining lease area, as I have pointed out, there was no surface right was given, and accordingly, the ingredients of the offense are not made out. Then coming to the section 409, may I take my lord?
409 you have already.
Another aspect is there. May I take my lord to section 212 of the CRPC?
Hmm.
212, Lordship.
Yes.
Particulars as to time, place, and person. The charge shall contain such particulars as to the time and place of the alleged offense and the person, if any, against whom, or the thing, if any, in respect of which it was committed, as are reasonably sufficient to give the accused notice of the matter with which he is charged. Then subsection 2. When the accused is charged with criminal breach of trust or dishonest misappropriation of money or other movable property, it shall be sufficient to specify the gross sum, or as the case may be, describe the movable property in respect of which the offense is alleged to have been committed and the dates between which the offense is alleged to have been committed, without specifying particular items or exact dates, and the charge so framed shall be deemed to be a charge of one offense within the meaning of section 219, provided that the time included between the first and the last of such dates shall not exceed 1 year. And herein the charge has been framed mentioning the dates, aforesaid period, in the first charge it is mentioned, the period is from first charge, line number 2, is for the period from 2004 to 2009.
37, huh?
Lordship, page 37.
Yes, 2000.
So, 2000. Firstly, for the first charge, Lordship, may I see?
Yes.
That you being the director of Mr. Snehapus Marketing Private Limited, as well as the power
During the period 2004 to 2009.
2009.
These are the claims.
So it is beyond the period of 1 year. and accordingly it's a decision.
What will be the impact of 460?
The charge will be cost. That is what I am showing.
No, what will be the impact of 464 then? Read 464, CRP.
464, Lordship, the will not cure this. Why I am pointing out page page current. Lordship.
It covers the error in charge of. Yes.
No, it will not be error.
Just see 464.
Lordship, kindly see the decision of the High Court of Gujarat.
Just see the provision. Whether it covers, then we will not labor on that.
No finding, sentence, or order by a court of competent jurisdiction shall be deemed invalid merely on the ground that no charge was framed or on the ground of any error, omission, or irregularity in the charge, including any misjoinder of charges, unless in the opinion of the Court of Appeal, confirmation a failure of justice has in fact been occasioned thereby. So, unless there is a failure of justice.
Unless there is a failure of justice, then this error can be ignored.
Lordship, whether it can be called as an error when it has been there.
You are saying that it is an error.
464 stage comes when the judgment is challenged. That
but that's right. But if it is substantially
if the trial goes on, I am convicted and I challenge.
Then in that you are right there. At the final stage that happens.
At that stage,
but the error is not fatal to the to you.
When error has been committed, is pointed out to the court. The court say that this will be cured in 464. So this error will be made.
Yes.
Lordship,
that is your answer.
Lordship, may kindly come to the
which judgment?
Memo of citations, the case of State of Gujarat versus Girija Sankar Das Joshi, which starts from running page 88 of my note of submission.
You read section
212 CRPC.
Section 212.
12 CRPC. Subsection 2 proviso.
Yes.
Proviso to subsection 2. Lordship, the citation, Lordship.
Yes.
In the list of citations which have been given, it starts from page 88, Lordship. I will take 88. State of Gujarat versus Girija Sankar Das Joshi.
Yes.
Page 89, Lordship, may kindly come.
At 89, huh?
89. From the top. The offence clearly falls under section 51C of the Prevention of Corruption Act as the charge in respect of dishonest misappropriation. 51C is identical to 409.
Yes, old act. Yes.
Lordship. The provision of section 222 of the Code of Criminal Procedure would apply as the period covered by the charge sheet should not exceed 1 year. But in this case, the period is from 1953 to 1960, and the charge is therefore clearly illegal and is quashed.
Yes, the provision so the code procedure would apply to the period covered in the charge. Yes. Yes.
Lordship. Then, Lordship, another important fact is that, Lordship, here in this case, Lordship will find that I am being charged for the offence under section 420 of the IPC, 409 of the IPC, and 379 of the IPC. My humble submission is that, Lordship, section 409 and 420 regarding a single transaction cannot go together.
Yes.
For constituting 420, the initial inducement must be dishonest. There must be dishonest intention on the mind of the person for causing inducement for the delivery of the property. And so far as the charge under section 40, the offense under section 409 IPC is concerned, the initial delivery is lawful. There is no problem. So either it will be an offense under section 409 or 420. Both the offenses cannot simultaneously go. In this regard,
Then you are choosing 420.
420 also I will show that the ingredients are not made out against me. May I point out this to Lordship?
Yes.
The relevant citation, Lordship, I am pointing out. Suresh Fakir Chand Parmar versus State of Gujarat, reported in 2015 Criminal Law Reports 157, para 23, Lordship, which starts from my memo of citation, the list of citations, page 86.
86.
Lordship.
Page 86. Yes.
Lordship, got it?
1 minute. I'll just reaching there.
Page
Yes,
86.
86. But it starts from page.
It starts from.
Judgment starts from page. No, this judgment starts from page 78.
78.
Page
78. Lordship, may kindly come to page 86, para 23.
86. Okay. Yes.
I am pointing out, placing Lordship.
22.
23.
23, yes.
The distinction between mere breach of contract and the offense of criminal breach of trust and cheating are fine one. In case of cheating, it depends upon the intention of the accused at the time of inducement, which may be judged by a subsequent conduct. But for this, the subsequent conduct is not the sole test, but mere breach of contract, which cannot give rise to a criminal prosecution for cheating unless fraudulent or dishonest intention is shown right from the beginning of the transaction, that is the time when the offense is said to have been committed. Therefore, it is this intention which is the gist of the offense. Whereas for the criminal breach of trust, the property must have been entrusted to the accused or he must have dominion over it. The property in respect of which the offense of breach of trust has been committed must be either the property of some person other than the accused, or the beneficial interest in or ownership of it must be of some other person. The accused must hold that property in trust of such other person. That's all, Lordship.
Yes.
Then, but the offense, that is the offense of breach of trust and cheating, involve dishonest intention, but they are mutually exclusive and different in basic concept. There is a distinction between criminal breach of trust and cheating. For cheating, criminal intention is necessary at the time of entrustment. In criminal breach of trust, mere proof of entrustment is sufficient. Thus, in case of criminal breach of trust, the offender is lawfully entrusted with the property and he dishonestly misappropriated the same, whereas in case of cheating, the offender practices fraudulent or dishonest to induce with another person to deliver the property. In such
Don't you
situation,
think that the trial is venturing into this aspect only, whether it is honestly interested or dishonestly interested?
there is absolutely no entrustment at all in my case. In my case, the reasoning why I am pointing out is that these are the basic fundamentals which the law students are asked in their exams. Whether for one single transaction an offense of 420 and 409 can be made out. And my humble submission is that the learned trial coach, which is senior court, has also committed the same mistake by framing charges for both the offenses. And I have cited another citation in this regard.
The proposition is clear. Let us proceed.
Lordship, next we will come to the charge under section 420 of the penal code. May I take my lot to the charge which runs at page 37 for the offense under section 420. 420. Yes, 420. Lordship, secondly, the charge is secondly that you working, Lordship got it?
Yes, 37, page 37.
Page 37.
Page
Charge with 7 heads.
37.
Secondly, the charge number secondly.
Yes, second.
Secondly, that you working as such during the aforesaid period.
Second, na?
cheated-
Yes, second 420. Yes.
you working as such during the aforesaid period cheated the government in connivance with the mining, forest and revenue officials and the lessee in conducting illegal mining of iron ore in the lapsed mining lease area of Jagdish Mishra and Uliburu Reserve Forest, which was the property of the government, causing loss to the tune of 1523 crore 59,48,527
Thereby committed
by dishonestly inducing that you raised iron ore
Yes.
within the mining lease area.
Here he says Jagdish as well as Mahathir.
So, Lordship, the charge framed, the allegation as spelled out in the charge do not satisfy the ingredients of the offense of cheating and therefore not sustainable in law, Lordship.
Yes.
The learned court below, without verifying and being satisfied about the accusations relating to the offense so as to find out as to whether the ingredients of the offense are prima facie made out, has framed the charge in a mechanical manner, acting as a post office, as because the aforesaid section of law is mentioned in the charge sheet. Here, Lordship, in order to point out the essential ingredients of the offense under section 420 of the penal code, I will take my lord to the case of Bishan Das versus State of Punjab and others, another reported in 2015 Criminal Law Journal 281. 281. Criminal law, which starts from running page 103 of my note of the list of citations.
103.
103 it starts.
2015.
Judgment is Lordship Bishan Das versus State of Punjab and another.
No, the
Supreme Court. Yes, Lordship.
Yes.
Lordship, may kindly come to the next page, 104, para 9. Para 9, Lordship.
104. 103 at 104, huh?
104.
Yes.
Para 9.
Yes.
The essence, Lordship got it.
10, no, para 9 is at 104.
104, in page 104.
No, 105 is para 9. At the essence. Yes. Yes. 105. 105.
Lordship. Para 9, Lordship got it.
You are missing one page, it seems. It is 105 in this my compilation. The essential ingredient to attract.
The essential ingredients to attract section 420 IPC are cheating. Number 1, cheating. Number 2, dishonest inducement to deliver property or to make, alter or destroy any valuable security or anything which is sealed or is capable of being converted into a valuable security. And third, mens rea of the accused at the time of making the inducement.
Yes.
54. Then, Lordship, I take my lord to another citation in the case of which I have already cited earlier, pointed out earlier. Who is the N. Raghavendra. N. Raghavendra versus State of Andhra Pradesh CBI, Supreme Court of India. Page, it starts from 42, Lordship. Page 42.
Yes. Yes, please.
Lordship got it?
Yes, I got it. Page 42 at
42 it starts. Then Lordship may kindly come to page 54.
yes,
54.
para?
Para 46. Last para.
Section
Section 420 Indian Penal Code provides that whoever cheats and thereby dishonestly induces a person deceived to deliver any property to any person or to make, alter, or destroy the whole or any part of valuable security or anything which is signed or sealed and which is capable of being converted into a valuable security shall be liable to be punished for a term which may extend 7 years and shall also be liable to fine. Then para 47, Lordship. It is paramount that in order to attract the provisions of section 420 Indian Penal Code, the prosecution has to not only prove that the accused has cheated someone, but also that by doing so, he has dishonestly induced the person who is cheated to deliver property. There are thus three components of this offense. Number one, deception of any person. Number two, fraudulently or dishonestly inducing that person to deliver any property to any person. Number third, mens rea of the accused at the time of making the inducement. It goes without saying that for the offense of cheating, fraudulent and dishonest intention must exist from the inception when the promise or representation was made. Then para 48.
Which, it's all right, I understood. Which ingredient is lacking in this case? According to you?
Person cheated. The person who gives a delivery of property must be cheated. This
So either it would have been Jagdish or
maybe Jagdish or maybe the state government over which land it is alleged that I have done mining. None of them have delivered any property to me. So the question of cheating does not arise at all.
So there should be a valid delivery first, thereafter everything
cheating
follows.
And the intention of cheating must be there at the time
Inception.
when the person makes the
Early inception,
inducement.
that's required.
So the ingredients are not fulfilled. Another decision is there. I have
Those in the
pointed out
same line.
same line
Same line.
on that. Then
Yes.
who has cheated whom, it is also to be brought out. Then we will come to the offense under section 460.
We'll continue.
We will continue at 2.
Continue. But you get that with affidavit, that Jagdish thing.
This thing I will, in the evening I will prepare that, I will submit tomorrow.
So we'll continue when, not today it seems. 2 baje, what? Special fixed matters are there. We'll continue, we'll continue.
To small
Just
revision
now
matters
or at
can
2
be
p.m.?
quickly listed. Can you dispose of?
Yes.
Just now we will continue or at 2 p.m.?
No, you next week, Monday, Tuesday continue.
Okay.
Tuesday, have you kept any matter at 2 o'clock?
Tuesday 2 o'clock fix kar jaye.
2 o'clock.
Right.
And get that and
Yes.
specify. I think how much time will you take now?
468. Next I am going 468 will take some time. Then about I will speak about 379, 411, 120B about the ingredients of these offenses.
411 is not charged against you.
No allegation.
No allegation.
And,
Charge is
37
not framed against
and 379, 411 you cannot allege against one person. You cannot say that he committed theft and
He kept
also got a
But it is
receipt
not,
list also.
charge is not against you.
No, charge is framed.
379 also.
379 also, 411 also.
But those things has to go. That's
And then I will have to lastly submit as to how the mollified in my prosecution.
Sir, how much time will you take? So about 1 hour, I think.
My lord, I will take
But you
half
have to
of
try
the
to
time.
do it faster.
Yes, about 1 hour. My lord, why your lordship will not take it another day? Why after
Yes,
lunch?
Tuesday, sir. Tuesday. Next
Tuesday.
Next Tuesday.
All right.
Next Tuesday.
So today there is no hearing after lunch.
No hearing today because there are specially fixed matters.
Yes.
Whatever Mr. Moon has argued now, I have to digest. It will take little time.
That's he has argued in merit. Lordship may dispose of the matter here.
I'm not in habit of hearing such a long way. Anyway.
So it will be taken up on Tuesday, my lord.
Tuesday. And try to summarize the argument. And keep the citations. I'll read it. And paragraph and all. Tell me. I'll read it. Need not read. And now only 468 you concentrate. The other thing is not required.
Briefly, I will submit.
120B.
Very briefly.
120B this general thing. No, that's not it.
General, but there will be some submission.
468 you concentrate.
Yes.
468.
Yes.
Then 379, 411, you ignore that, only 468.
Sir, namaskar, sir. Sangram. Sir, namaskar, Sangram, sir.
Namaskar.
Sir, बहुत दिन पर देखिल, sir. We miss you very much, sir.
Okay, you see me in this. Are you okay?
हाँ sir, बोलो sir.
अच्छा.
Sir, oil sir, pranam.
हाँ, pranam. संग्राम बाबू आपण अछंती ना पळेलेनी नाही से पळेलेनी 30 कहले
Let it lie over matters. We'll fix that here. It can be heard
Next
next
week I'll take it.
Yes.
Prepare a note and give. Then decoy witness has gone hostile. And then who is supporting you?
Well, I haven't gone through the files, my lord. This is what he has been submitting with Mr. Das.
I have prepared a note, my lord.
And my lord,
What are the materials are against you?
And my lord, secondly, we are not having the appeal memo also.
The prosecution case, my lord, the accused never demanded or accepted bribe from me. The person never demanded.
Who all are there?
Decoy, my lord, the informant.
Or who else are there?
He has stated that money is meant for steno.
What is the trial court says?
Appellant is working as a senior clerk.
What is the trial court says? Why trial court has convicted you?
Grounds for that sort of a commission question.
Reasoning.
He has turned hostage, my lord.
What is the trial court's
finding
regarding this? There must be some reasoning, not that trial court has convicted.
Must be a section 20 presumption there must be.
No, but if he says that there is no demand, it is not meant for. How will you bring?
He must not have been able to dispel the presumption under section 12. There are many similarly situated persons, so we are going chronologically.
You have give it to him so that they'll prepare and argue.
Only son Milot is working in a petrol pump. Financial.
It's all right. You have a good case on merit.
Yes.
Give the papers to him so that they'll collect it, and I'll put it to whenever you you are ready, come and mention it. Let it be there.
Yes.
Monday you come, I'll mention at the moment they are ready. Be ready on Monday. I'll hear it. No problem.
Yes,
Give the copies to me.
yes, I.
Give the copies.
In fact, Mondays also there's many prefixed matters. So board is
It's a very
totally
small
tight.
matter. There is nothing.
Like, according to him, my lord, I haven't gone through the entire brief,
First
and I
reading-
don't have the appeal memo also. That's what I was telling him.
He
sir.
will give whatever paper he has.
Yes, ma'am.
He'll give. Just go through.
Ma'am.
Let us see if it is a case of acquittal. We'll deal it and
Yes,
finish it up. At least he'll get benefit.
Yes, ma'am.
Otherwise, what is the use of it?
Ma'am.
If it will take little time,
Ma'am.
there is no scope of acquittal.
Ma'am.
Then we'll adjourn it.
Yes, ma'am.
Just within 5 minutes, we'll just go through and give the copy. Yes.
Item 18.
Yes.
Item 18, may I please, your lordship?
Now you ask.
Lordship, the petitioner has convicted under section 354 and 448 of IPC and sentenced to undergo SI for 6 months, and under section 354 sentenced to pay one fine of 1,000 rupees, and offense committed under section 448 of IPC in default to undergo SI for 15 days.
Sentence is 6 months.
6 months.
Yes. Yes.
Let's see, the occurrence has happened on 16th for 2005 at 8:30 a.m. After that, the FIR was lodged after 10 days delay. And there is no eyewitness.
What are the allegations?
Allegation is, let's say, the accused petitioner jumped to the wall boundary of the informant and took away his son and threw on the ground. Then the informant assaulted the accused by means of a steel glass on his face of the accused. Then accused has left from the spot. Then the informant reached out to his her elder sister-in-law after her taking bath. The informant narrated this incidents before her. Both the informant and her sister-in-law went to the house of the accused Narendra, and then they saw accused was going by his bicycle. Then the accused informant and sister-in-law told his parents of the accused and his two sisters about this incident. In spite of taking any action, they threatened to remain silent.
Yes.
At that time, her husband was not at his village. After his return from the husband was working at as a supervisor security guard at the Bangalore. After his return, the informant and his wife, her husband went to the Tiring PS and lost the affair before IIC.
When the FIR was lost?
Lost, let's say 25/4/2005.
25/4.
4.
The incident taken place on
16/4/2005.
16/4.
10 days delay. Let's say.
How the prosecution has explained that delay?
That's it.
How the prosecution has explained that delay?
That's it. Her husband was not there, not at his village.
No delay. How the delay is explained? by the prosecution. Come to para 8. Para 8 of
Learn.
appellate court order.
Learn.
Have you read it or not?
Learn. The occurrence took place on 16/4/2005, whereas the FIR was lodged
Para
on
8 of appellate court order. The next argued by.
it is next argued by the Law and Counsel for the appellant that the occurrence took place on 16/4/2005, whereas the FIR was lodged on 25/4/2005, and there is absolutely no explain for such delay. It is, however, observed that the informant has stated at para 11 of her deposition that her husband returned after 10 days of the incidents, and on the very day he lost the affair by going to the PS with him. The trial court has also considered this aspect by the observing that when the modesty of a married woman is in question, it is very natural that she would contact her husband, and hence the delay of 10 days is not at all fatal to the case of the prosecution.
Yes, this is how the delay is.
Delay.
Next, what are the next point? Delay is explained because it is a case of outraging the modesty of the woman, and the women did not go to the police station till the husband
come to the house.
came. He was somewhere else. He came after 10 days. Thereafter, the FIR was registered. So that is why the trial court says that the 10 days delay is not better. Next point.
Let's say there is only a ground that PW6 Bonamali Giri stated that the informant, the petitioner, the 10 and 12 years dispute between on a civil matter.
Okay. There's enmity.
And there is no occurrence witness. And the charge of the 506 of on IPC has not made out on the trial.
Yes.
And during the incidents happened in the baranda, it is that attached to the village road.
Why don't you argue in a structured manner? One sentence you are saying, stopping thereafter another sentence. What are your points? First is delay. Delay in FIR. You have argued that that is dealt with by the trial court. What are the next points? And thereafter, what are the evidence thereafter? What is the discussion? You argue in a structured manner. One sentence you are saying, you are leaving that and going to the another sentence. Don't do that. In a structured manner, you do it. Yes, he should get one more opportunity to argue in a structured manner. But tomorrow.
Let's see.
Tomorrow. Yes. Let him prepare in a structured manner and argue tomorrow. Yes. And get judgment also. Yes. Weekly. Yes. Revision matter, Mr. Raghuda, we will just run through what are the small matters. We will dispose it up, and the other matter will see.
Small matters, 37 is the small matter.
37.
And 44 is a small matter.
37, 44, anybody is there? What, let us see. 37. Small matter we should try to dispose it of. 37, huh? What is this matter, Joe? 37, what is this?
Yes. In fact, the accused petitioner, by forcing the appointment orders, he managed to join as assistant
Oh,
teacher.
that is para 14, PW7.
No, this is another one.
But the problem in this case is it was never listed after 2009. First time it is listed. Who is appearing?
The findings is that the conforming CGM's
Who is the lawyer? Who is the lawyer? Hmm? Who is the lawyer? In absentia, we can do. Who is the lawyer? Huh?
Oh, teachers means Jayant Rath will be there.
In the year 1991, he was 45 years. 70 something.
May I take his well-being and also inform Mr. Rath, senior advocates, because he usually appears to the teachers.
Appeal was filed in the year 2009. The petitioner was, the appellant was 56-year-old. None appears for the appellant.
45 years.
56. That is the cause I think.
In fact, the impugned judgment, Anantisa, 45 years.
But see, 2009 it is 56, it is written. Well, let us see. None appears for the appellant. From the record, it is found that Mr. Jayant Rath had entered appearance at the time of filing of the petition. Mr. Das, land counsel, for the Vigilance.
I will also inform him.
Undertakes that he would inform Das, Mr. Rath, regarding the listing of this matter. And in the meantime, he will also seek an instruction from the department regarding the well-being and whereabout of the petitioner. Where is that? Who? There is a direction. It should be that he is from where?
Puri.
Puri, SP Vigilance.
No, I got that instruction from
Puri. Inspector of Puri.
Bhubaneswar.
Bhubaneswar.
Puri is under the SP Bhubaneswar.
Bhubaneswar. Being directed by SP Cuttack, inquired into the allegation.
No, I got the instruction which is
Bhubaneswar.
Bhubaneswar.
SP Bhubaneswar is directed to inquire about the well-being and whereabout of the. I'll list it on 29 because the other matter, Mr. EGB's matters are also there.
Yes, Manoj, on 29.
29, we'll deal with that. Oh, free copy for
that will be SP Vigilance.
SP Vigilance.
SP Vigilance.
Yes. SP Vigilance, Bhubaneswar. Yes, 30 and next 37 and 30.
44.
44.
This is that matter, my lord, sir. You have lordship aware.
Yes. What
Look,
is this?
that the accused had gone to the Acharya Harihar Cancer Institute with his ailing mothers for treatments, my lords. And she procured the medicine as per the advice of the doctors, my lords. And she procured 4 cash memos. And while submitting for reimbursement, my lords, the cash memos exhibit 5/4 and 5/2, 5/7. My lords, appears as some kind of manipulation, some kind of overwritings, my lord. And 1 year.
Show me the exhibit.
Exhibit page 17 is the findings, my lord.
No, show me the exhibit. Let us see.
Yes, my lord.
Exhibit.
5/4 to 5/7.
Exhibit, 5/.
5/4. There are 4 cash memo in total. 5/4, 5/5, 5/6, and 5/7.
Where is the manipulation? It's not to be seen. What is the amount?
Amount is penalty amount is 50.
Have you approved this exhibits through whom?
Yes.
Through whom?
Through the PW. PW 10.
10. What does he say? No, he was an associate.
So doctor. PW 10 is doctor. Sorry. This patient's read with me. Evidence of
He has given
1, 4.
prescription.
1, 4, and 6 proved.
In the prescription, there is no manipulation.
I'm sorry, PW 1, 4, and 6 proved all the beyond all reasonable doubt that exhibit 5/4 to 5/7 are not genuine statement. PW 1, 4, and 6. The entire prosecution case raised on them. 1, 4, and 6. These features, read with my earlier analysis on the evidence of PW 1, 4, 6, proof beyond all reasonable doubts that exhibit 5/4 to 5/7 are genuine document, are not genuine documents. So the conduct documents.
One 4, yeah.
One is the proprietor of that shop.
I read it. And
Sanjeevani Medical Store.
4 is Ramachandra Bhanja Medical College. I have been working in.
And then 6.
They say that this case memos
Sanction only 40,000.
No, they say that these memos are not issued by us at all. All the witnesses. It's not manipulation. Not manipulation.
Not genuine documents. That's Lordship, I gone to that exhibits, no?
Exhibit, and I read the evidence also. Who is he was being
Mr.
Some Bini Mishra.
Mr. Bhalls asserted that lady doctor.
No, she appeared last time.
And she also assured a file and note, small note or something. He's a very sincere guy. And she showed up.
Tell her, huh? Tomorrow. I'll finish it up. I read it. I read it.
And she got that, he got that 40,000 rupees sanction amount, 40,000.
That is a crime by desperation.
Naturally, when any person, man, we are the creature of circumstances.
Desperation. Mother was
Correct.
in
It's not
bedridden,
a habitual
cancer
matter.
patient,
It's not a
acute.
habitual one.
So offense is 468 and all.
468,
But
471,
problem here,
1 year and at 1,000 fine.
but the problem is he was working in government peon.
Yeah.
If he is convicted, but what is his age, let us see.
Age will be 46 at the time of, in 2010, he was 46. Meantime,
We'll see whether acquittal may not be possible because we'll see later. You tell her, huh? Tomorrow. Tomorrow I'll take it up. Yes. Come to 68, huh? Okay.
68.
You please inform him, her also.
I'll inform both the lawyers.
So that we can finish these two matters. Yes, 68. Yes. This is. Okay.
Convicted under section 376, 450.
Hmm?
376, 450. Convicted. Imprisonment 7 years and fine 2,000.
This is an appeal.
Revision.
Revision.
There was starting last occasion, there are two cases, my lord. One case 498 that are judgment is reserved, and this case is here. Since 376, he wants to argue this case, my lord. Suddenly.
None appears for the petitioner. In the interest of justice, urgent one. Next we will see. Otherwise we will see.
69.
There is that.
Mm, 69.
Yes, madam.
Nah. It is only convicted under 323, 326. 1 year, 323, 3 months, 326, 1 year.
Convicted under 341, 323, 326.
Should lower court.
Lower court. After appellate court, like a set hela. 341. I mentioned the offense under section 323, 326.
Yes.
They are informant and some of brothers. That is a family.
They're real brothers.
Yes.
Also. What have you done? Within your brother.
It is not a written. Yes.
Written. You want that conviction and sentence you can take.
No. I want benefit of probation of offender.
What do you say? What intended?
1 year.
How much you want to go? I'm to go.
Very less, 1 month.
How much you pay me? You have any idea?
1 month.
Don't tell me. No, you can tell me so that I will be written in the Have you verified it? When he was taken into custody and when he was released on bail, tell me. So that I record it and be undergone and do whatever. Just now, let's see in proceedings. Wait, huh? Then, if you know, period of custody right now. Period of custody will tell. Otherwise, I'll dismiss people. Many times what happens, when I say tell the period of undergone, you say yes, there are things don't come. Then I'll dismiss your petition. Remember, if you don't tell me the period of custody. See the file, original record is there. Just find out. If you can't find out, tell that I could not find. Not that you don't come, that thereafter our staff is keeping on calling and we are not responding. This is very bad man. In many cases it happened.
16 year, my lord. The sentence in a life,
I know.
what would be harder?
No, that's right. But what which part for the body? Let's see. On different sides, one cut injury size of so to the right eye. One cut injury in the dorsum of the left right palm. One drilling. Only injury number 3 is biggest.
On bottom of left arm.
Injury number 3, which is in the palm, is grievous.
Grievous is there, madam.
Grievous one injury number 3.
That only injury number 3 is grievous in nature or the subsequent. So find that injury number 1, 2 might have been caused by subsequent or injury
simple.
Number 3 is grievous, madam.
I know that feeling. And it is 1 year, na?
1 year.
Let us see how much he undergone. What we do is, after the period, the PO impose heavy fine.
Yes, yes, madam.
And the fine amount will go to the victim injury.
Madam.
Tell me the thing. Undergone and fine increase. See, the incident had taken place in the year 2003. 2003. You record and check it up. Yes.
70.
Yes.
492, 04, 34 of 40 madam.
The party heard of
Within 1 year of marriage. Within 1 year of marriage, madam.
307?
No, 304B. 304B is there, madam. 7 years.
Convicted by both.
7 years. Both. Appellate court confirmed it as well, madam.
Sentence?
Sentence like 498 no separate sentence. 304B 7 years punishment and 4 declared.
Agrees is none appeared. Yes.
21.
No, there is an indication that no original will be given in the court. Still nobody is coming what to do.
One minus 207 offense. 2.5 years conviction and 1,500.
72. Yes, offense.
We have one offense 452, 324, and 34 IPC. So, on this one,
307 years. 23.
Four mandated, 34 minor. Convicted 2 years, 2,000 rupees fine. And will also confirm.
Sentencing?
Convicted, trial for convicted, 2 years minor. 2,000 rupees fine.
In all these things, have you seen, have you checked that undergone period?
Oh, my God.
In the record, please check up the undergone period so that if suppose a substantive sentence is already undergone, we can think of this.
Only trial court record we can.
Yes, there are the record is there. In when little time, we can find out. Then only we can dispose it up. Otherwise, I don't think nobody is coming forward what to do. You can't dismiss him before a keep of, suppose I appoint a MAK today. Next time the MAK theory comes prepared, the lawyer also comes. And if we are wasting the time of but so this is the attitude what to do. We sorted out these matters because all those cases are.
NCR matter listen back and the subcommittee there matter. It's not possible to read out this period of how many days in the custody.
You can't access to the. You have to sit with the staff and the.
Anywhere, that order is not available. Not after. And the NCR matter, not competent person.
Problem is it is outsourced. Then they have nothing to do with the law, they have no knowledge.
Yeah, just doing
They don't know which document actually can pass, which is.
Even the chronology is disturbed.
There is no chronology, nothing. You keep on searching.
Upside down, what is the sentence?
How
period undergone.
also what to do? You can't employ your own staff to do it. Even the, if it happens subsequently, once the.
And nowadays, now even if you are after 2022, the trial courts giving the custody period and everything.
That's the minimum. That we are struggling.
Yesterday, I have engaged a special engineer for number of 5 matters, crime matters. They are the lordship that you obtain certificate from the jailer, from that time that you custody certificate.
In Supreme Court, when you file, custody certificate, they must. You don't give question certificate, it cannot be numbered.
Yesterday, court instructed me.
Can we do all these things in all these matters? The custody certificate for
Cases matter. Even if that is available in the jail matter. Some where the after included 7 years of consistency, that will be easily available in the jail and after matter. So, but the bureau of justice matter.
Why don't you ask it? Why are you waiting for court order? You can ask. And so you ask the custody people so that we may not tell them. Write letters in all the matters.
But
then the individual order I have to pass.
report may be called.
Huh?
A report may be called from the court.
But then individually I have to.
The jealous, all the jealous will verify, yes. And that will be more indicated also. This is what happened, my lord. Some are relevant nature, but that case, even if the accused ever went to the jail,
Those cases not because 307, 498 and
06.
Yes, 306. 395, I have seen the appropriate couple of cases. 73 cases. 74.
74.
Anybody is ready to argue the matter? Anybody is there to argue, ready to argue matter any? Are you ready? Are you ready?
Yes, but LCR
78.
Yes, only arrived period is 6 months.
So you see the LCR now. See LCR, huh? Let's be there. Tomorrow we'll take it up. Tomorrow we'll take it up. See the
Okay.
And anybody? Ram, keep on calling. Here, Mr. Mishra, do you have any matter to argue?
LCR is not.
Just see and tell me. Tomorrow I'll take it up. Huh? Anybody who is there, they can very well utilize it. If nobody is there, then we just check the LCR.
Take a soft copy of the LCR.
Yes, give me false copy.
LCR is.